everyone. In this video, I am going to talk about an interesting situation which we often come across in a domestic arbitration, where an arbitration clause providing for a seat of arbitration is in conflict with the exclusive jurisdiction clause. There is usually no difficulty on this front where the seat of arbitration is consistent with the exclusive jurisdiction clause. However, the problem arises when the clauses are conflicting with each other, invariably giving opportunity to the counterparty to raise a jurisdictional objection. This in turn delays the effective adjudication of any arbitration-related litigation and consequently the arbitration reference process. The question arises as to how do we resolve this ambiguity and how do we deal with such a jurisdictional objection. It is a settled position of law that a seat is akin to an exclusive jurisdiction clause. This essentially means that the court located at the seat will exercise supervisory jurisdiction over the arbitral tribunal, and all arbitration-related proceedings are to be filed there, unless there is a contrary indicia emanating from the contract itself. As per the law laid down by some of the high courts, all arbitration-related proceedings would lie before the court where the seat is located, notwithstanding the exclusive jurisdiction clause conferring jurisdiction on courts at a different location. There are, however, conflicting decisions of some other high courts which hold that an exclusive jurisdiction clause providing for a different court is itself a contrary indicia and would prevail over the seat of arbitration. The complexity increases when instead of specifying seat, the parties use words like venue or place of arbitration in an arbitration clause. There are precedents which hold that venue and place can also be interpreted to mean the juridical seat of arbitration in appropriate cases. But in cases where there is also a conflicting exclusive jurisdiction clause, the usage of the words venue or place may not have the same effect as that of a seat of arbitration. One has to be extremely mindful of the conflicting decisions of the high courts, which may have a binding effect depending on the courts where such a jurisdictional issue comes up for interpretation. This is extremely critical as the jurisprudence around this is still evolving in the absence of a definitive judgment of the Honorable Supreme Court in the context of domestic arbitration. Therefore, while negotiating a contract, and particularly the dispute resolution clause, it is extremely critical not to loosely use terms like seat, venue, and place, as each of the terms have different connotations and implications. It may also be advisable to involve the disputes team early and take their strategic inputs preemptively before agreeing and finalizing the dispute resolution clause in a contract to mitigate the risk of such jurisdictional objection.